ਅਸੀਂ ਨਾ ਇਹ ਬਜਾਏ ਆਪਣੇ ਕੇਸ ਦੀ ਸੋਚਣ ਦੇ ਬਜਾਏ ਇਹਨੂੰ ਓਵਰਆਲ ਇਸ ਮੀਟਿੰਗ ਦਾ ਜਿਹੜਾ ਮੇਨ ਮਕਸਦ ਸੀ ਕਿ ਲੋਕਾਂ ਦੇ ਵਿੱਚ ਇੱਕ ਗੱਲ ਪਹੁੰਚਾਓ, ਉਹਨਾਂ ਨੂੰ ਦਿਮਾਗ 'ਚ ਪਾਓ ਕਿ ਬਈ ਇਸ ਟਾਈਮ ਤੁਹਾਨੂੰ ਅਗਰ ਆਪਣੀ ਇੱਜ਼ਤ ਪਿਆਰੀ ਹੈਗੀ, ਆਪਣੀ ਮਿਲਟਰੀ ਰੈਂਕ ਦੀ ਇੱਜ਼ਤ ਪਿਆਰੀ ਹੈਗੀ ਹੈ, ਤੇ ਤੁਹਾਨੂੰ ਐਟਲੀਸਟ ਫॉर ਗॉड ਸੇਕ ਇੱਕ ਆਪਣੀ ਜਿਹੜੀ ਤੁਹਾਨੂੰ ਇਨਜਸਟਿਸ ਦਿਖਾਈ ਦੇ ਰਿਹਾ ਹੈ, ਉਹਦਾ ਸਰਕਾਰ ਨੂੰ ਇੱਕ ਲੀਗਲ ਨੋਟਿਸ ਤੇ ਦਿਖਾਈ ਦੇਣਾ ਚਾਹੀਦਾ ਹੈ ਤੁਹਾਡੇ ਵੱਲੋਂ, ਇੰਡੀਵਿਜੂਅਲ ਵੱਲੋਂ। AFT is not looking, AFTs will not look into एसोसिएशन। और अजय भी अगर मूर्ख आदमी, अगर मैं ओपनली कह रहा मूर्ख, अजय तक 60 साल तक भी अगर लोग ये नहीं समझ रहे हैं कि भाई AFT इंडिविजुअल ही जाता है, तो फॉर गॉड सेक टेक द एडवांटेज ऑफ वन लीगल नोटिस व्हिच इज ऑलरेडी इशूड, and I am doing your work on your instructions.
Individual can also be individual and others. AFT only individual.
Sorry?
Individual जो लोग कहते हैं, when we say association cannot file a petition in the AFT. When you talk of individual, is it sanctity of an individual or individual and others ही हो सकते हैं?
This
notice अपन देता हैगा Bhardwaj and others.
Sir, I think yes, you are right. You can, they allow जो चार पार्ट बंच बना के तुसी बना दो, but my legal advice is, since it is a matter of pension of one individual, एक दी observation सारे ने 5 ਨੂੰ रोक देगी, पूरे केस ਨੂੰ रोक देगी। एक ਦਾ ਸਾਰਾ ਹੋ ਸਕਦਾ ਕਿ ਕਹਿੰਦੇ ਨੇ ਉਹਦੀ ਵੈਰੀਫਿਕੇਸ਼ਨ, ਇੱਕ ਦੀ ਵੀ ਵੈਰੀਫਿਕੇਸ਼ਨ ਨਹੀਂ ਆਈ, ਉਹਨੇ ਕੁੰਡੀ ਪਾ ਦਿੱਤੀ, 5 ਰੁਕ ਰੱਖ ਜਾਣਗੇ। ਸੋ ਇਟ ਇਜ਼ ਬੈਟਰ
ਜੋ ਵੀ ਕੇ ਬਾਤ
ਇੱਕ ਨੇ ਵੀ ਸਾਰੇ ਰੁਕ ਗਏ। So always and every time when it comes to financial matters, क्योंकि ਇਹਦਾ ਅਖੀਰ ਵਿੱਚ ਆਰਡਰ ਬਣਨਾ ਹੈ ਇੰਡੀਵਿਜੂਅਲ 100%, ਕਿਉਂਕਿ PPO ਉਹ ਜਦੋਂ ਬਾਬੂ ਹੈ ਨਾ ਉੱਥੇ CDS ਦੇ ਵਿੱਚ ਜਿਹੜਾ ਉਹਨਾਂ ਜਦੋਂ ਆਰਡਰ ਆਣਾ ਵਾ ਤੇ ਉਹਨੇ ਅਗਰ ਉਹਨੇ 5 ਦੇਖੇ ਨਾ ਤੇ ਉਹ ਅਕਾਊਂਟ ਡਿਪਾਰਟਮੈਂਟ ਦੇ ਵਿੱਚ ਜਦੋਂ ਤੁਸੀਂ ਸੀਰੀਅਲ ਨੰਬਰ ਦੇਖੋਗੇ ਨਾ, ਤੁਹਾਡੇ ਸੀਰੀਅਲ ਨੰਬਰ ਦਾ ਡਿਪਾਰਟਮੈਂਟ ਵੀ ਅਲੱਗ-ਅਲੱਗ ਹੋਣਗੇ, ਕੋਈ ਆਰਟੀ ਦਾ ਹੈ, ਕੋਈ ਇਨਵੈਂਟਰੀ ਦਾ ਹੈ, ਕੋਈ
ਨਹੀਂ ਉਹ 5 ਜਦੋਂ ਕੁੰਡੀ 5 ਨਹੀਂ ਉਹ ਕਹੇ 50
never don't even think of, each one has to be that is very important, right? Now luckily what we have in hand is that one side there is a now opening of individual short service commission officers to go individually based on the legal notice into the AFTs, but one of the AFT, that is AFT Chennai, in the case of almost a similar case, using the same, where he has also used his my services as by showing the legal notice, that AFT said we do not have the power to handle this case. They do not have the power to handle this case because it is a policy matter. And then I contested. I did say so. Like I said, it is not a case of policy matter. Policy was already existing, pension regulation para 30. This is a case where army instructions have been, have been put in a way or made in a way that nobody reads para pension regulation 30. So the whole environment, whole system, starting from the CDA, from the army headquarters, from the Air Force headquarters, Navy headquarters, whosoever would have, because the whole short service commission started initially because of this army instruction 62 and emergency commission plus this thing, so 64. So पूरा environment जो डिफेंस सर्विसेज के अंदर उसमें हो गया, पेंशन रेगुलेशन सबके लिए कॉमन है, आर्मी एयर फोर्स नेवी के लिए। तो ये जो पहला एक सिलसिला शुरू कर दिया कि पेंशन अंडर कंसिडरेशन ऑर्डर विल बी इशूड सेपरेटली, दिस हैड ए डोमिनो इफेक्ट एंड एवरीबडी एनवायरनमेंट के अंदर एक कुकून बना दिया, क्रिस्ट बना, एक बैरियर बना दिया कि एसएस वाला तो बात ही नहीं करेगा अपनी पेंशन की, जबकि ऑथराइज्ड है अंडर रूल 30 पेंशन रेगुलेशन 1961।
ओके, पेंशन रेगुलेशन एक्ट या तो 30 कह रहे हैं,
यस,
व्हिच entitles every officer or jawan or everybody, only officer की बात है, only officer to have the benefit of pension.
Yes.
Okay. Now number 2, that is as per the Army Act. ਉਦੋਂ ਕੋਰਟ ਕਹਿ ਰਿਹਾ ਸੀ ਕਿ ਆਦਿ ਕਵਰਡ ਅੰਡਰ ਦੀ ਆਰਮੀ ਐਕਟ ਆਫ ਨੋਟ
Army Act-
ਰੈਗੂਲੇਸ਼ਨ ਤੇ ਐਕਟ ਅਲੱਗ-ਅਲੱਗ ਨੇ ਦੋ ਚੀਜ਼ਾਂ
नहीं sir, Army Act is for everybody.
everyone ਹਾਂ
It is
it's a broader framework.
In short, this has been, there is no doubt about so far. Officer, there is no word as short service commission officer in Army Act. There is only one word, officer.
Yeah.
It is it has got nothing to do. Short service is a scheme. But over a period, this
The
has
nature
got-
of entry. It's one method of entry.
No, method of entry only one. Once you are done your basic training and you have been attested and you have taken the oath, then thereafter you are an officer.
Okay.
Everybody is an officer.
So next week ਇਹ ਜਿਹੜੇ ਥੋੜੀ ਆਰਮੀ ਇੰਸਟਰਕਸ਼ਨਸ ਹੈਗੀਆਂ ਇਹਨੇ ਉਸ
They are administrative.
regulation
Ah. Army instruction is an administrative instruction.
and the
signed by-
regulation is what? It's a legal
Statutory. Oh, statutory.
Yes, statutory. ਜੀ ਇਹਨਾਂ ਨੇ ਇੰਸਟਰਕਸ਼ਨ ਨਾਲ ਉਹ ਉੱਤੇ ਢੱਕਣ ਲਾਤਾ
हाँ, करेक्ट. उन कवर करता, एक्लिप्स करता. सर ऐसा है.
100% इंडियन है.
हाँ, simple है. If I am now your advocate, I now openly will say so. I should advise you correctly. If you have now, if I am your advocate, then it is my, I am duty bound to tell you the legal, this thing, every correct legal point. Okay, don't get into traps. Now based on that, sir, when AFT Chennai has, like the way I filed for you here, because you gave me instruction, similarly there is one officer, Captain Major Dr. Bharat, who gave me instructions to file a similar for a OA claim, pension claim at Chennai. Now this OA, this is very important. Chennai, ਜਿਹੜੀ AFT ਹੈਗੀ ਹੈ, they went differently. They said we do not have the powers to handle since it's a policy matter. I did say so, it is not a policy matter. Policy is already existing because of Rule 30, Pension Regulation 1961. Only thing, this administrative instruction is creating an impediment in getting that particular rule followed, and not for only for him. It is, the culture is into the armed forces for the last 60 years, and nobody is questioning. So here this gentleman has come and seeking your, I will say, intervention, but they said no, simply not. So based on that particular thing, now it's very important, sir, because I have created the whole now synopsis of this case. I'll request you to allow me to, it may take 5-10 minutes of yours, because it's very important to understand this synopsis of the whole now whatever. Sorry, I became emotional about making people understand कि भाई कोई समझ नहीं रहा है, क्योंकि ये मैं पहली बार नहीं कर रहा हूँ, मैं पिछले 10 साल से शोर मचा रहा हूँ. So synopsis मैंने ये वर्कआउट किया है. Now this particular will make you understand that we are going to the apex court now with this prayer, and of course I will not disclose all the papers because that is including of individual, but synopsis. At sometimes once it is accepted, it will be shared also. Synopsis क्या है sir? That the present civil appeal is being filed. Civil appeal is being filed by the appellant against the impugned judgment and final order dated 6/8/2025 in OA diary number 722 of 225 passed by Armed Forces Tribunal Regional Bench Chennai, and the Hon'ble Tribunal Bench dismissed the same. Now this is the cause of concern. That the petitioner got commissioned in the Indian Army on 8 January 1999. I think that was the time I retired also. In the rank of Lieutenant and Short Service Commission Officer in the Army Dental Corps, initially for a period of 5 years and further extended to another 5 years of service and promoted to the rank of Major. The petitioner retired on 6 March 2009 in the rank of Major after serving 10 years, 1 month and 26 days. The Short Service Commission Officer are appointed for a fixed tenure in the Indian Army, Navy and Air Force depending on the branches, because I have to explain and tell the people, because you see, likha hua hai. The Short Service Commission Officer typically serves 5 years extendable to 10 years or 10 years extendable to 14 years, and upon completing their tenure without converting to permanent commission. Short Service Commission Officers are released Short service commission officers are performing identical duties and facing the same risks. SSC officers historically receive no retiring pension as on date. The only retirement benefit granted under Service Rules and Army Act 1950 has been terminal gratuity, which is very meager. आपके लिए 1000 रुपए दी थी आपको. That the Armed Forces Acts do not guarantee any pension or permanent status to short service commission holders. Rather, SSCs are issued with the understanding that on expiry of their contractual period, they will be released from service with no claim to further service, which is totally illegal in violation of Article 14 and 21 of the Constitution of India. There is no difference between SSCOs and permanent commission officers in terms of selection procedures, physical and medical standards, mandatory dress, postings, duties, liabilities, etc. There is also no difference between SSCOs and permanent commission officers in terms of subjection to service acts such as Army Act, Air Force Act and the Navy Act. Okay, I have to tell and explain to the Honorable Apex Court. And rules and regulations made under the said acts. There is also no difference between the short service commission officers and permanent commission officers in terms of their subjection to other services, rules, regulations and policies governing their duties, liabilities and discipline. Now this is very important. Discipline remains the same. There is also no difference between SSC and permanent commission officers in terms of liability to be sent to battle zones, war zones, counterintelligence or counter-terrorist operations. Therefore, there is no reasonable classification or difference in the kind of quality and nature of service being rendered by SSCOs and permanent commission officers towards the safety and security of the country, that despite rendering a decade of dedicated and disciplined service, the applicant has been denied pensionary expectations, which stands in stark contrast to the treatment afforded to SSCOs governed under Army Instruction 11 S of 64, which is part of my OA. That AI 11 S of 64 applicable to SSCOs of combat and support arms, including law qualified officers, explicitly includes a saving clause under para 17 SSCOs for grant of pension under constitution order will be issued separately. Though ultra virus, when Rule 30 of Pension Regulation Part 1 of 1961 existed to compute pension for officers served less than standard years of service under Rule 29 of Pension Regulation. अगर मैंने 20 साल की है तो मेरी स्टैंडर्ड सर्विस हो गई, और अगर मैंने कम किया तो कितना मैंने डिडक्ट करके इसको पेंशन देनी है. इट इज 29 में पूरी स्टैंडर्ड है, पैरा 30 के अंदर डिडक्शन है. 10 साल की है तो 10 साल का होगा, 5
ये रिडक्शन जो है ये क्वालिफाइंग सर्विस जितनी है उसके ऊपर डिपेंड करता है, ये रैंक वाइज.
यस, उसमें पैरा 30 ये उसी में
इसमें ऐसे होगा ना.
यस, डिडक्शन होती है
रैंक वाइज.
यस, रैंक वाइज नहीं, रैंक वाइज जो भी आपने रैंक है उसके उसमें कहा वो अच्छा बहुत टेबल बना हुआ है सर, बहुत अच्छा बना हुआ. Let me finish this. These provisions reflect a continuing governmental. Now this is very important. These provisions reflect a continuing governmental obligation to consider pension benefit for SSCOs who served under honorable terms and were released as per organization needs and no fault of their own. क्यों हमने terms and conditions में कि 5 साल ही रखना तुझे, बस काम कर. So you are released. However, the petitioner short service commission officers from special services like the ADC are governed under Army Instruction 1517, which clearly omits this saving clause. See the beauty. जितने भी डॉक्टर्स हैं उसमें ये सेविंग क्लॉज भी नहीं लिखा हुआ. जैसे कि ये फाइटिंग आर्म्स को सपोर्टिंग ये जैग वालों का लिख दिया, वो पेंशन अंडर कंसिडरेशन ऑर्डर, उनकी इंस्ट्रक्शन में यही है ही नहीं, तो ये आर्मी इंस्ट्रक्शन में ही नहीं डाला. That this omission creates a serious anomaly and results in unconstitutional discrimination among SSCOs also. Even though all such officers, regardless of their corps, serve under the same Army Act, the same hierarchy, bear equal risk and uphold the same military discipline. There exists no intelligible differential to justify exclusion of AMC, ADC, RVC released SSCOs from consideration for pension, while their peers in other corps benefit from continuing pension-related legitimate expectation and review under 11 Army Instruction 11 of 64. इसको कहते हैं legitimate expectation. तुसी तुझे 50 साल तो सरकार दी वेट करते रहे, हुक्म आएगा तो मैंने legitimate expectation है मेरी. Right? You are not okay. It's okay. You are not applied earlier. Legitimate expectation is a very important theory under which it's called a trust.
Trust.
I trust you, and then I expect that return will be given to me. The onus is now the government to fulfill this legitimate expectation. The contention of the petition that the phrase pension under consideration order will be issued separately must uniformly apply to all categories of short service commission officers, including those in specialist services. The absence of this provision in Army Section 15 of 79 is not only arbitrary but violates the equality principle enshrined under 1416 of the Constitution. Such exclusion effectively splits a single class of SSCO'S into unequal subcategories. क्या कमाल हो गई? आपको अलग रेगुलर कुछ बता दिया, आपको कुछ बता दिया, डॉक्टरों को कुछ बता दिया. Those with prospective pension consideration and those left in neglect, despite an identical tenure, rank, and responsibilities, that the denial of post-service financial support after over a decade of commissioned service infringes the right to livelihood under Article 21, denies legitimate expectations and undermines the morale of commissioned officers who willingly serve the armed forces under short term in the interest of armed forces organizations. It also contradicts the intent of welfare principles under the pension regulations for and defeats the spirit of one rank, one pension. अरे मेरी वन रैंक है, मेरी पेंशन, ये मेरी जनरल सतवीर से लड़ाई हुई थी कि यार शॉर्ट सर्विस थी वन रैंक की, पा दे ड्राफ्ट एक लाइन एक पॉइंट पा दो, तुसी 14 पॉइंट लिखेंगे क्या शायद लिखो तो सही, सरकार के पास बात तो करो. Especially when pension is granted to other similarly situated counterparts. That the legal notice was issued to respondents on dated 4/1/2025 जो मैं रेफर कर रहा हूँ. And following relief were asked from the respondent: A. Compensate my clients for the losses and hardships caused by arbitrary release without pension and adequate social security. लिखा है, part of my prayer in the legal notice. B. Grant pro rata pensions oblique OROP and extend full medical coverage. I said full medical coverage here to my clients. You all are my clients. In line with pension regulation as it exists for others in the armed forces. And C. Frame and implement a comprehensive rehabilitation policy for released SSCO'S ensuring their financial and social security. The respondent has not given any reply to the legal notice. Then the petitioner filed the original application before Hon'ble Armed Forces Tribunal, Bench Chennai on 30/7/2025. अभी मैं जो करके आया, wide OA diary number so and so. After hearing the original application, dismissed the OA in limine on the point maintainability by stating that thus it only stands to reason that a tribunal subject to the High Court's jurisdiction under Article 226 cannot be permitted by law to direct the framing of policy of the government. Thus, the tribunal is not invested with jurisdiction to adjudicate the issues involved. ये order में उसमें लिख के दे दिया, speaking order के अंदर. The Armed Forces Tribunal Chennai bench dismissed the original application for lack of jurisdiction to direct the government to frame policy or extend pension. Reliance was placed on Union. This is मेरे जो Reliance was placed on Union of India versus Commodore N.K. Sharma, Union of India versus Purushottam, Union of India versus Simo Devi. The petitioner commissioned status and identical service conditions to PC officers warrant pensionary parity. No, with no uncertain terms.
Related to which all common, sir? All are common.
I am claiming under these laws.
Yeah, all are common. Sorry.
Yes. Denial of pension violates the Article 14 and 21 and the principle that pension is vested property right under property right आपका. मैं एक दिन भी काम करूंगा वो उसके साथ भी मेरी पेंशन बनती है. एक प्राइवेट सिक्योरिटी गार्ड का एक बंदा लगता है 10 महीना लगता है, उसकी नाल प्रोविडेंट फंड पीएफ शुरू हो जाता है, उसकी पेंशनरी बेनिफिट नाल शुरू हो जाता है. The issue affects a broader class of SSC officers, raising questions of equality, dignity, and morale within the armed forces. Given the tribunal's limited jurisdiction, only this honorable court can provide authoritative relief. The Honorable Supreme Court. That in view of the Para 17 Army Section 1164, the heading of pensionary terms, wherein it is written that these are under consideration and orders will be issued separately, this word pension under consideration in Army Section 1164 has perpetuated exploitation. with no uncertain terms I am writing, and financial insecurity for petitioner and similar situated SSCO'S who served as disciplined and trained officers under short service commission terms. This clause has enabled authorities under your control to arbitrarily deny pensions and other critical benefits to SSCO'S, causing irreparable harm to the petitioner. I will not plead for you of this thing. It is very much they were to give us. So the petitioner requests Honorable Court to direct the respondents to recognize this structural discrimination, hold that all SSCO'S, irrespective of course, infantry, RT, doctors, must be equally entitled to pension consideration and accordingly issue directions to extend pensionary benefits to the petitioner with petitioner to major bharat hai sir. It's okay. With retrospective effect. Relief is also sought for areas and other further orders deemed just and appropriate. मैं लिखा आपकी इसमें लिखा इंटरनल रिलीफ क्या पड़ा कि give him at least to look at, give him at least 50% till the time you decide on merit. Hence this civil Hence this civil appeal petition in these circumstances it is submitted in the interest of natural justice. This honorable court may please to grant the permission to file this civil appeal against this civil appeal मुझे file करने की permission नहीं पड़ेगी अब judgment of the Honorable Armed Forces Tribunal bench Chennai. तो उस ऑर्डर के केस मैं सरकार के पास जा रहा हूँ. So sir, this is I have date of events how I have worked starting from 1961 आर्मी रेगुलेशन जो the आर्मी इंस्ट्रक्शन जो है 62 का भी मेंशन कर दिया है so that emergency commission officers do not get this thing. They are also included in this particular 70 से लेकर 90 successive batches of SSC officers commissioned into the army, navy and air force to tenure of 5-10 extendable up to this thing. Then the terms and conditions of service for officers granted short service commission officer ये attach कर दिया है, ये लिख दिया है.
बस ये attach तो सीखने laws आ गए ना law attach कर रहे.
सर पूरी वो एप्लीकेशन होती पूरी लगेगी होती भारती.
law लगेगा ना नाजिया भी कोर्ट कर रहे हैं. सर वो की कर रहे हैं what is the process like?
हाँ या वो सर ऐसा है ना at this stage ये merit पे नहीं डिस्कस करना. बेसिक हैगा भी इतने डायरेक्टली वायलेशन हैगा भी प्राइमा फेसी वायलेशन दिखाई दे रहे.
इंस्ट्रक्शन ਦਾ ਲਾਅ ਦੇ ਦੱਸਣਾ ਪੈਣਾ ਇੰਸਟਰਕਸ਼ਨ ਤੇ ਨਾਲ ਅਟੈਚ
ਉਹ ਲੱਗਿਆ ਹੋਇਆ ਉਹ ਜਿਹੜੀ ਓਏ ਦੇ ਵਿੱਚ ਉਹ 90 ਉਹ ਆਲਰੇਡੀ ਲਿਖਿਆ The terms and condition of service for granted short service commission the army dental code अच्छा dental code का भी लिख दिया उसकी army instruction भी डाल दी. Terms and condition of service for officers granted short service commission officers dental code का भी डाल दिया. इसी प्रकार से medical वगैरह petitioner was selected for grant of this thing ADs इसी medical का भी इसमें आ गया. In the case of Union of India versus SPS, a very famous case. SPS Vance का case है. The Supreme Court ruled that military officers of the same rank who retired before January 1990 must receive the same pension as those retired after that date. The court held that government's practice of creating a disparity based on retirement date was arbitrary and violated the principle of equality. That the petitioner was promoted to the rank of major and leads to वो सारा डाल दिया. So basically it's a sequence of events and finally that the petitioner filed the original application before the Honorable AFT Chennai on so and so date. After hearing the original application dismissed OA in limine on the point of maintainability by stating thus, it only stands to reason that the tribunal subject to High Court's jurisdiction under this thing cannot be permitted by law to direct the framing of policy by the government. Thus, this tribunal is not invested with jurisdiction to adjudicate the issue. That's why this is not. कितने AFTA एडवांटेज ना लगे कि तुम मेरे को आज आए थे मैं आज तो देनी है तुम पेंशन.
That was very only meant for the applicant when applicant
in the OA.
In the OA.
So once a precedence is set by yes, it has to be done from the date of his retirement 2009. It will be done for everybody.
जेडे बंदे पहली वाली बंदे सीगे उन्हें वास्ते नहीं है ना.
सर ये जो उन्हें वाले अरे यार जनाब हाथ जोड़ के बड़े समझो पहलो. पॉलिसी केड़ी तरीके दी बनी है 1961 ਦੀ ਪੈਨਸ਼ਨ ਰੈਗੂਲੇਸ਼ਨ 1961 ਪੈਰਾ 30 ਉਹਦੇ ਬਾਅਦ ਜਿਹੜਾ ਵੀ ਰਿਟਾਇਰ ਹੋਇਆ ਉਹੀ ਪੈਰਾ 30 ਲਾਗੂ ਹੋਏਗਾ. ਤੁਸੀਂ ਪਹਿਲਾਂ ਰਿਟਾਇਰ ਹੋਏ ਹੋ ਜਿਹੜੇ ਸਾਲ ਦੇ ਐਮਰਜੈਂਸੀ ਕਮਿਸ਼ਨ ਅਫਸਰ ਲੈਟਰ ਦੇ 1964 ਨੂੰ ਰਿਟਾਇਰ ਹੋਇਆ ਹੈ ਤੇ 65 ਵਿੱਚ ਹੋਇਆ ਹੈ, ਉਹਦੇ ਉੱਤੇ ਰੂਲ 30 1961 ਦਾ ਹੀ ਲੱਗਣਾ ਹੈ ਨਾ, ਤੇ ਉਹਨੂੰ ਪੈਨਸ਼ਨ ਰੈਟਰੋਸਪੈਕਟਿਵ ਇਫੈਕਟ AFT ਦਾ ਉਸ ਡੇਟ ਤੋਂ ਸ਼ੁਰੂ ਹੋਏਗਾ ਜਦੋਂ ਰਿਟਾਇਰ ਹੋਇਆ।
ਇਟ ਇਜ਼ ਆਟੋਮੈਟਿਕ ਸਿਸਟਮ।
ਇਟ ਇਜ਼ ਆਟੋਮੈਟਿਕ ਸਿਸਟਮ ਬਿਕੋਜ਼ ਇਹ ਪ੍ਰੋਬਲਮ ਤਦ ਆਉਂਦੀ, ਇੱਕ ਮਿੰਟ ਸਰ, ਜਿਹੜੀ ਤੁਹਾਡੀ ਡਾਊਟ ਤੁਹਾਡੇ ਦਿਮਾਗ 'ਚ ਕੀ ਆ ਰਿਹਾ, ਇਹ ਡਾਊਟ ਤੁਹਾਨੂੰ ਤਦ ਆਉਂਦਾ ਕਿ ਪੈਨਸ਼ਨ ਰੈਗੂਲੇਸ਼ਨ ਆਮ ਇੰਸਟਰਕਸ਼ਨ ਪਹਿਲਾਂ ਬੜੀ ਹੁੰਦੀ ਪਰ ਪੈਨਸ਼ਨ ਰੈਗੂਲੇਸ਼ਨ ਬਾਅਦ ਦੀ ਹੁੰਦੀ। ਇੱਥੇ ਤੇ ਉਲਟਾ ਹੈ, ਇੱਥੇ ਪੈਨਸ਼ਨ ਰੈਗੂਲੇਸ਼ਨ ਆਲਰੇਡੀ 1961 ਦੀ ਬਣੀ ਹੋਈ ਹੈ, ਸ਼ਾਰਟ ਸਰਵਿਸ ਕਮਿਸ਼ਨ ਦੇ ਬਾਅਦ ਸ਼ੁਰੂ ਹੋਈ ਹੈ।
ਇਮੀਡੀਏਟ ਰੈਟਰੋਸਪੈਕਟ ਜੋ ਵੀ ਹੋਏਗਾ ਕਿਸੇ ਬੰਦੇ ਦਾ ਵੀ ਇਟ ਕਵਰਸ ਰਾਈਟ ਫਰਮ ਦੀ origin
What he is trying to
ਐਕਟ
ਤੁਸੀਂ ਅੰਡਰਸਟੈਂਡ ਕਰ ਰਹੇ ਹੋ, ਭਾਰਤ ਦੇ ਕੇਸ 'ਚ ਬਾਕੀਆਂ ਨੂੰ ਬੈਨੀਫਿਟ ਮਿਲੂਗਾ ਕਿ ਨਹੀਂ ਮਿਲੂਗਾ, ਇਹ ਜੋ ਕਹਿ ਰਹੇ ਹੋ ਤੁਸੀਂ।
एक्ट तो शुरू होगा, जो एक्ट की सारी कवर होगी।
I don't know what order यार वहाँ पे नहीं सके
यार एक मिनट
this order की order होना we don't know।
No, I'll explain you with your this thing। When you will go हम तो सी AFT ਦੇ ਗਏ ਬਾਦਲ ਦੇ ਕੇਸ ਵਿੱਚ, ਬਾਦਲ ਦੇ ਕੇਸ ਮੇਰੀ ਪ੍ਰੇਅਰ ਕੀ ਹੈ, this prayer is lagu to you only, not to KP Singh।
To me, boy, you
yes, no,
but otherwise this policy whatever retrospective effect will
एक आप पढ़ो, मैं आपको प्रेयर आपकी पढ़ा देता हूँ। Relief song, this is very important। In view of the effects mentioned in para 4 above, the petitioner prays for the following reliefs with costs. Applicant hence prays direct the respondent to grant service pension to the applicant with effect from 29 April 1979 date of release based on 9 years and 2 months of qualifying service with consequential arrears and benefits including OROP adjustments. This is your relief sought. 1. Declare para 17 of Army Section 11 as of 64 as a valid and binding promise giving rise to a legitimate right to pension. मैं कहना मेरे पास ऑर्डर वही होना चाहिए सी रूल 30 with further prayer that respondent may please be directed to award interest on the delayed।
it is subject to the concerned person।
हाँ, लेकिन अगर आप AFT के ऊपर भी जाके ये छोटी सी एप्लीकेशन नहीं दोगे एक सिंगल शॉर्ट्स ऑफिसर इंडिविजुअल, तो आपके घर में नहीं आएगी पेंशन। एंड सेम शुड बी वेरी क्लियर टू दी एसोसिएशन के जो मेंबर्स हैं, क्योंकि एक इंडिविजुअल को ही एंड में आना पड़ेगा AFT के सामने। There is no other constitutional body which can give a order to the respondents. Which are the respondents? Union of India, Additional Director General, Personal Services, to CDA. So in short, with whatever little understanding today after today's meeting, if we are able to understand the importance of each individual filing his own case in the AFT, I think we have achieved the aim of making each one understand. And I'll request कि दूसरा भी तुसी समझाओ, make the other people understand this is the basic document which is required for which your pension will be considered. And for that, to make this document complete to be submitted to AFT, there is a requirement of attaching the legal notice of that individual who has given instructions, How do I decipher? ਮੈਨੂੰ ਕਿੱਥੋਂ ਪਤਾ ਲੱਗਦਾ ਹੈ कि ये बंदे ने लीगल नोटिस इशू किया है? जो कैप्टन राजेश जो है, जिनका वो जो हमारा लीगल फॉर्म है, ही इज सपोर्टिंग थ्रू IT सेल एंड हिज सपोर्ट, तो जो उसके अंदर वो डाटा एंट्री करता जा रहा है, उसका हम लीगल नोटिस कंप्लीट कर लेते हैं। वो लीगल नोटिस को इसके साथ जो मैंडेटरी रिक्वायरमेंट है ऑफ दैट द रेमेडीज एग्जॉस्टेड, रेमेडी एग्जॉस्टेड, वो अटैच हो जाता है। उसके बाद आपकी डेट को और ये पेंशन रेगुलेशन को दे के उसमें आपके कितने साल से कौन सी तारीख से आपकी पेंशन बनती है, एरियर्स कितने बनते हैं, वो इसके अंदर एक पेंशन क्लेम का हम प्लीड कर लेते हैं। नाउ अगर चंडीगढ़ AFT हैज ऑनर्ड अस, it has not outrightly rejected. Since Chennai has rejected in Bharat's case, so I am lawfully now going to the Honorable Supreme Court to give directions to AFT Chennai that this wrong is being done. मेरा कोई तो माई बाप होना चाहिए as a released short service commission officer. ये थोड़ी we are going round and round on the same. मतलब we are officers under Army Act. We have been released. Injustice has been caused to us. Inequality has been seen. Everything is, we are seeing the injustice for last 60 years. Now once we want to seek relief and justice, there has to be something in this, within the nation. And the only forum which is available is AFT. So AFT must allow our pension.